To our final conversation. Courtrooms often mirror the tension between law and conviction. This scenario is playing out as the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, has withdrawn his plan to call 23 witnesses in his terrorism-related trial. Kanu told the Federal High Court at Abuja that entering a formal defense would be futile, arguing that there is no valid charge against him despite the court's earlier ruling that he has a case to answer. The judge directed him to file a written address outlining his stance and adjourned the matter to the 4th of November. By choosing not to open a traditional defense, Kanu rests his case on a no-case submission, leaving the court to decide directly on judgment without further defense evidence. I mean, BKO, looking at this, what are the legal implications of Nnamdi Kanu's decision to rest his case on a no-case submission? Is he making an error here?
I don't know where the inspiration to do this came from. In criminal procedure, once a defendant fails to enter a defense after being told to do so, the court is empowered to proceed to judgment based on the evidence provided by the prosecution. His case, unfortunately, might be decided based on the prosecution's case because he has refused to enter any form of defense.
Defense.
I listened to him on the day when he listed a number of prominent people as his witnesses. General T.Y. Danjuma, an old man approaching his 90s. Nyesom Wike. And the question is, after saying all that, after firing your lawyers, including the great Kanu Agabi, who has so much experience, you said you were going to defend yourself. So once you said that, the court will expect that you put in your defense in writing. But he then changed his mind that, okay, at this point, I'm not even going to enter any defense. The court has a jurisdictional issue. The court cannot try me. These are issues that he earlier brought up in his no-case submission. Issues that had been decided upon. The issue of whether the court has jurisdiction to put you on trial was decided in that no-case submission that failed. This is what is bringing back again to say, oh, no court in Nigeria. I've heard him say that the offense that he committed was committed outside Nigeria, therefore no court in Nigeria can put him on trial. So as far as it's concerned, the court does not even have jurisdiction. That is despite the fact that the matter of jurisdiction
has been
that brought up had been decided by the court when he filed a no-case submission. But at that point, the ruling was that you have a case to answer, go ahead and prepare your defense. He also brought up the issue of the appeal court judgment. The appeal court ruled that Nnamdi Kanu should be freed because the manner in which he was rendered to Nigeria from Kenya was against international law. In international law, you cannot repatriate an accused person in the manner that they had done without an extradition trial. So that point was made by the appeal court, and the appeal court ordered his release. Kanu made this point late last week that this court, Justice Omotoso's court, should release him based on the appeal court judgment, whereas the appeal court judgment had been set aside by the Supreme Court. So I don't get it. The matter of his report, the medical report,
Yes.
that the court mandated the NMA to evaluate and report to it. The NMA report says Kanu is fit to stand trial. When that report was presented before the court, Kanu's lawyers did not object to it. In fact, they even cross-examined the doctor.
All right. Okay,
Now,
Biko,
you are bringing that up.
Okay.
Well,
Biko, I need you to just
you are
pause for a bit. We need to go on this quick break, and when we
Okay.
return, we'll continue with this conversation. Don't go away. It's still Journalist Hangout. All right, you're welcome back to the show. It's still Journalist Hangout. All right, so Biko, I need you to land on your thoughts before I come to Asuko James.
going to make was that his lawyers did not object to the medical report that the NMA submitted to the court. So if you are going back to bring back matters that have been decided by the court, it looks like a strange strategy because it means simply that we are relying on a strategy that has failed. When a no-case submission is filed, it suggests that you think that the prosecution does not have a prima facie case or has not established a prima facie case against you. But the no-case submission was dismissed. So once it's dismissed, you then have to defend yourself. So what he's doing is legally precarious. And I've read other lawyers say, look, you can't do this. The court will not bend its rules because of an individual. So it looks like the court will just simply go ahead and enter judgment in this matter because the defendant has not elected to defend himself.
I mean, some have even called it a procedural gamble.
No, of course. Remember, I think it was last week, I was saying that I think he made an error, for him to have, told his lawyers to withdraw from the case that he wants to defend himself. Because this is a big case. It's a high-profile case. And he shouldn't have, I was thinking he would even come back and say, okay, I think I've gotten lawyers now. I made an error. These are my lawyers.
Or is this to draw public sympathy?
And we said this, is how many people are out there talking about it? Everybody is just pitying him for making that error. They're pitying him. Because what we wanted was for him to just see how we can, even all the witnesses. Now he did not even call witnesses. And if you don't call witnesses, it means that you're on your own. Because
exactly.
If you don't call witnesses and you even go in front of the judge, you are going to be defending yourself based on law because you don't have any facts. Sure. But now that he has decided to close his case, it means that the judge will be making use of what the prosecutors actually presented, which is both fact and law. And I don't know how he wants to remove himself from, because it's like he has tied himself into one corner. He has pushed himself into a corner, and then he has left himself for the judge to decide on what to do. Nigerians everybody is watching.
Exactly.
And just like we said last week, and even BK has said in the previous editions, is we wanted this case to be done for, so that we'll move into other things. And he had good lawyers who would have presented and helped him out. There is no lawyer who has his own onions that will say he wants to defend himself. A lawyer will look for a lawyer to defend him in any case. So not to talk of somebody who doesn't have he doesn't know the letters of the law.
Right.
You know.
Okay.
So I don't know how this case will be. I just pity him. That is the only thing I want to say.
Absolutely. Absolutely. But anyway, Asukwo James, thank you so much for having this conversation.
Thank you so much for having me.
BKO, all the way from Abuja, in our Abuja studios. Thank you so much for having this conversation with us.
Thank you, Benga.
And we look forward to seeing you in Lagos.
And let him bring Kilishi.
Kilishi. All right then. And that's it on Journalist Hangout today. Join us tomorrow for another episode of the program. You can watch the repeat broadcast of this episode tonight at 11. Join us on Sunday from 1:30 to 3:30 p.m. for Journalist Hangout on Sunday. We are on YouTube at youtube.com/TVC News Nigeria. I am Benga. Bye for now, and God bless Nigeria.